Welcome to another episode on the Law Report. I believe that this is episode 32. Today I would like to discuss an issue that has garnered high media attention in the Turks and Caicos Islands and has been trending for days on social media, and this concerns the disciplinary committee of the General Legal Council in Jamaica issuing its decision on the 29th of July 2022, finding Miss Sophia Thomas, an attorney at law, of violating the canons of professional ethics while prosecuting a fraud case in the Kingston and St. Andrew Parish Court in 2017. A date is to be set to give Ms. Thomas an opportunity to mitigate before the committee impose sanctions on her. So why am I talking about this? It's because Ms. Sophia Thomas is a public prosecutor in the Office of Director of Public Prosecutions in the Turks and Caicos Islands. Before I discuss the matter in depth, my usual disclaimer: this is not legal advice, should not be construed as legal advice, and for legal advice please contact an attorney of your choice. Welcome back. The complaint was made against Miss Sophia Thomas in 2019 by one Lowell Spence, a national commercial bank manager who was freed of fraud charges in November 2017. The complaint stemmed from the case that Ms. Thomas was prosecuting while she was attached or a member of the Office of the Director of Public Prosecutions in Jamaica. And while prosecuting this case, Ms. Thomas attempted to refresh a witness' memory from a statement. The defense attorney in the case sought to have sight of the statement. When the statement was handed to defense counsel, he realized that the statement was a photocopy and not the original statement. Counsel then objected that the witness should not be allowed to refresh his memory from the photocopy statement. It is alleged that Ms. Thomas then advised the trial judge that the original statement was at her office. As a result, there was an adjournment to give her time to retrieve the original statement. When the matter resumed, Ms. Thomas proceeded to hand the witness a document without showing it to defense counsel. Defense counsel objected, and as a result, the document was handed to counsel on the directions of the trial judge. Counsel for the defense then compared the photocopy document that was previously disclosed to him and this document that was just handed to the witness, and the defense counsel identified that there were 11 differences between the two documents. From the evidence before the disciplinary committee, it appears that Ms. Thomas led the trial judge to believe that this statement was the original statement. Under cross-examination, the witness admitted that he signed the purported original document a day before court. So clearly, this could not have been the original document from which a copy was previously disclosed to the defense. This caused another adjournment, and when court resumed, the Director of Public Prosecutions of Jamaica intervened and offered no further evidence in the matter. I will read briefly from the decision of the disciplinary committee. At paragraph 70 of the decision, the disciplinary committee writes, "We consider that the respondents," and this is reference to Ms. Thomas, "conduct was gross and repeated and therefore intentional in misleading the court as to the provenance of the so-called second original. It was not a simple mistake or error in judgment. Being an attorney of 9 years practice at the time and 5 years with the Department of Public Prosecutions, she ought to have known the proper procedure in proceeding to refresh a witness's memory. The manner in which she proceeded to circumvent the process by obtaining the court's permission was not exemplar of honesty and candor. Acquiring a reproduced document with an original signature bearing a back date and a failing to inform the court of the absence of the original smacks of pursuing a course to have the use of the document at all costs, or certainly without regard to candor in the face of the court, truth, due process, and fairness to the defendant." And at paragraph 71, the decision says, "For these reasons and for those reasons set out in our analysis in paragraph 56 and 63 above, we find the respondent's conduct was such that she failed to maintain the honor and dignity of the profession, and her behavior discredited the profession of which she is a member." And at paragraph 72, the disciplinary committee embarked on a fact-finding mission. So it sets out at paragraph 72, "The panel makes the following findings as it is obligated to do by virtue of section 15 of the Legal Profession Act. At the trial date of 7 November 2017, the respondent did not lay the foundation of the use of the photocopy statement to be used to refresh the witness's evidence, as she indicated to the trial judge that the original was at her office. That based on the respondent's indication that the original was at her office, and on the respondent's application, an adjournment was granted to produce the original statement. The respondent made checks at her office and discovered at that time that the witness's original statement was mislaid or lost. The witness did not have another original of the statement he gave in May 2017. The respondent spoke to Mr. Hines and requested that he ascertain from the witness whether he had the original statement on his computer, and if so, he should reprint it for presentation at the trial. At the trial date of the 22nd November 2017, the respondent did not inform the trial judge that she had not found the original statement and that she had secured a reprint before having the document passed to the witness. That the statement presented was not a replica with an original signature of a second original, but a new document with changes both to grammar and the content, though the changes were not material. The respondent did not check the statement to ensure that the reproduction was an exact replica of the original. The respondent did not know that the document delivered to her by Mr. Hines had some changes to content, though not material. And finally, the Director of Public Prosecutions offered evidence in the matter against the complainant. And in conclusion, the committee states, having carefully considered the evidence, the panel finds that the evidence presented by the complainant in relation to one of the grounds of complaint has met the requisite standard of proof, that is proved beyond a reasonable doubt, and that the respondent has violated the canons of professional ethics. In particular, the panel finds that the respondent has failed to maintain the honor and dignity of the profession, and her behavior discredited the profession of which she is a member, and that the respondent failed to maintain her integrity and counseled others to act in a manner injurious to the legal profession. The panel therefore finds the respondent is guilty of professional misconduct as per Canon 8D, in that she had breached Canons 5.0 and 1B of the legal profession, Canons of Professional Ethics rules, in accordance with the procedure recommended by the Court of Appeal in Owens, Clooney and General Legal Counsel. The panel directs that a date be fixed to give the respondent an opportunity to be heard in mitigation. Now, because of the media attention, specifically social media attention garnered by these findings, the Director of Public Prosecutions in the Turks and Caicos issued a brief press release, and as I mentioned earlier, Ms. Sophia Thomas is now a public prosecutor in the office of the Director of Public Prosecutions in the Turks and Caicos Islands. I'll read the press release. Decision of the Disciplinary Committee of the Jamaica General Legal Counsel concerning Ms. Sophia Thomas, Senior Public Prosecutor with TCI ODPP, meaning the Turks and Caicos Islands Office of Director of Public Prosecutions. The Office of the Director of Public Prosecutions and the relevant TCI stakeholders are aware of the 29th July adverse decision of the Disciplinary Committee of Jamaica General Legal Counsel concerning Ms. Sophia Thomas, a Senior Public Prosecutor with the TCI Office of Director of Public Prosecutions. The public interest and concerns the matter has generated are understandable and duly noted. I confirm that this matter is receiving due and urgent consideration, and a further press statement will be made in that regard in due course. Signed, Eugene Otoni, QC, Director of Public Prosecutions. Now I have a few questions in conclusion. One, did the Office of the Director of Public Prosecution in the Turks and Caicos Islands, or the committee, or whoever did the interview, were they aware that Ms. Thomas had these ongoing disciplinary proceedings? If they were not aware, was this something that Ms. Thomas should have brought to their attention? And 3, knowing that these matters were hanging over Mrs. Thomas's head, should they have hired her? These are legitimate questions to ask. I do not wish to put forward an opinion on these questions. I will invite viewers to comment as they see fit. And in closing, I have my own experience while defending a matter in which Ms. Thomas was the prosecutor, and I will share that experience in another episode. I thank you for watching, and I see you in another episode.